The second accused highly regrets the inconvenience caused to the court and to all the parties, my lady. He had not wished to be the reason why perhaps today's session will be delayed or will be interfered with in whatsoever manner. And I did tell him, my lady, that we'll propose to court that we can dispense with his presence, because today's session is simply to highlight submissions. Either we dispense with his presence, my lady, even as we highlight on his behalf. And if that will be contentious, then we'll be very, we'll be kind to ask for an adjournment. I was speaking to senior counsel this morning of the repercussions of the second accused success. And I was of the opinion, my lady, because it is just highlighting on submissions, and the second accused has acquiescence to allowing, to asking court to dispense with his attendance even as we highlight the submissions, he will not be having any problem, my lady.
Concerned that there's no documentation before you, even an admission note. This would have been at least appropriate.
You have also taken note.
The absence of even an admission document, just to prove that he's in hospital. This would have been the appropriate step to take to satisfy the court that he is indeed not available. My lady, the second accused has stated that he's ready to, the second accused counsel has stated that the accused person has said that we can proceed with the highlighting. My lady, the only problem is that we have nothing from the accused person telling us that at this late stage. So, on my front, unless I get other directions, I'm a bit hesitant to proceed. If it looks like the accused person.
You are saying the accused two counsel has indicated that accused two?
That accused, the second accused, accused two, is ready to proceed with highlighting without his absence. Without his presence, sorry. That is, we are able to proceed without his presence.
The problem you have with that is?
My lady, the only issue I have at the moment is that we don't have the sentiments of the accused person, even in writing or even on virtual, so that technically we'll be proceeding with a hearing when he's not present. And I would not like that to be an appealable issue as we move forward. That's technically. My lady, with guidance from the court, I'd be seeking something in writing, or just to say we can proceed, or we take another date, my lady, or we all forfeit the highlighting so that it doesn't look like we have proceeded without him being present.
But I also have a duty to quote. The absence of the second accused is a significant issue. The Constitution at Article 50, Subarticle 2F requires the personal presence of all the accused persons at the trial. And that right is ring-fenced by Article 25, that you cannot restrict that right. And so the absence of this accused person makes it difficult if we are going to do the submissions. Because if we go ahead, it may turn out, and we've read other cases in this jurisdiction and others, where the trial is declared a mistrial and you have to start all over again because of that kind of violation. So yes, I am ready to proceed, but there is that aspect of the second accused's presence. I had the prosecution make what I considered to be a reasonable proposal, that we have all of us put in written submissions. If there is consensus, we can forego the highlighting and we ask the court to look at our written submissions. From experience, when we start highlighting these submissions, we will simply be going back to what we've written before court and bringing it to your attention. On my part, I am willing to forego the right to highlight so that we don't delay the trial any further and we rely on our written submissions. The proposal came from the prosecution and I thought it was reasonable. Thank you, Your Lordship.
I have considered the submissions that all counsel on record have made. With regard to the absence of the second accused and his proposal that the court would consider proceeding with the highlighting in his absence. I agree with the prosecution counsel that learned counsel for the second accused should have availed to the court evidence confirming that the second accused was indisposed and was currently admitted in hospital and was therefore unable to attend the court today. What counsel is basically asking the court to do is to rely on his statements from the bar, which cannot take the place of evidence. The prosecution counsel has, however, indicated that she has no reason to doubt that the second accused is admitted in hospital and has therefore not requested the court to issue a warrant for his arrest. And in the circumstances, I will say no more in that regard. A proposal was made that hearing could proceed in the absence of the second accused, but this is a direction the court is not willing to take, given the constitutional safeguards ring-fenced to the right of an accused person to a fair trial, which includes the personal attendance of an accused person during the trial, unless his conduct makes it impossible for the trial to proceed, which is not the scenario in this case. So in the premises and in order to ensure that this very odd case is fast-tracked to conclusion, and as all counsel on record have confirmed their willingness to forego highlighting of their written submissions, they have also confirmed that they are comfortable relying on the written submissions on record. I will accept that confirmation and direct that the matter will now proceed for judgment. So we are going to have the matter mentioned on a date that we agree virtually for purposes of fixing a judgment date. And all accused persons, including the second accused, must attend that mention. The second accused will also furnish the court with medical evidence regarding his alleged indisposition before that date. So the proposed dates for mention, the first one is on the 18th of March. So councils, look at your diaries.
But Lady, just for good order, will the mention be physical or virtual?
I said virtually.
Virtual.
Yes.
Virtual. They can have whichever date.
Yeah.
18th.
That appears convenient.
That's convenient.
18th of March.
18th of March. What time, Your Ladyship?
We can do it at 9:30, hoping that I will not forget like the last time.
No, this time we'll remind you. My lady.
But next time, remind me before I start with the cost list for Muranga,
We
so
will
that I
remind
start
you.
with you and discharge.
Very well.